the Supreme Court, in the case of Baba against Nigeria Civil Aviation Training Authority, established it beyond doubt that when it comes to revenue tribunals, they are not bound by the strict rule of evidence. So that's the first thing that you need to know about the tribunal. We are not bound by the strict rule of evidence. Admissibility is basically based on relevance. So when you're coming before us, always bear that in mind. I think that's just what I want to stress as we go on. If there are questions, we'll answer it. Now let's go to the meat of my presentation, which I have called the circle of tax dispute. In my view, there are actually 5 stages in a tax dispute. Now, the first stage is what I have called the trigger stage or the catalyst phase. Now, this phase is actually a spillover from interaction or perhaps failed discussion between the tax authority and the taxpayer. Now, when they fail, because there is an in-house mechanism to resolve dispute at that level, Section 69 makes provision for in-house mechanism to resolve tax dispute. Now, when that fails, and oftentimes it will, it triggers the jurisdiction of the tribunal, because it's at that point that recourse is made to the tribunal. But at that stage, 3 things could happen. The first one usually will be, please go to circle of tax appeal. I think this should be a slide. Go to slide 9. Slide number 9. So now, at that point, 3 things could happen. The taxpayer may file an objection, go through the procedure, and then wait for the issuance of notice of refusal to amend NORA. The second one, he may file an objection without waiting for NORA. He can then appeal to the tribunal. The third one, he may not even file an objection. Once there has been discussion and there is a failure, he may just appeal directly to the tribunal. Now, if you follow the case of Ohando Trading, Supply and Trading Company, you will see that the tribunal has held that NORA is not a condition precedent to appeal before the tribunal. So the trigger stage is that stage where the taxpayer decides that he's taking his matter before the tribunal. The second stage in the life of an appeal is what I call the forum selection. And this is very important because if you filed an appeal before the tribunal and the tribunal does not have jurisdiction to hear that, your appeal is incompetent and we will throw it out. Now you will know that the tax appeal tribunal is not the only forum that hears tax disputes in Nigeria. You have, to some extent, even the magistrate court can intervene. Then you have a lot of states who have created their own parallel, bodies. Sometimes they even have their own state laws, state tax laws, strictly speaking. And then you have the Federal High Court. Of course, even the Supreme Court has original jurisdiction even in tax matters. So you need to then identify where you are to file your appeal. You need to look at it critically. And 3 things will assist you in determining whether your matter can come before the tax appeal tribunal. The first one is the parties. The first one, the parties. Now, when you look at the provisions of our law, you will see that by necessary implication, only a taxpayer and a tax collector are competent parties before the tax appeal tribunal. So if your issue has to do with dispute arising from maybe production sharing contracts amongst members of that arrangement, might not be a matter that the tribunal can actually look into, because by necessary implication, the dispute, tax dispute, must involve, at level of the tax appeal tribunal, must involve the taxpayer and the tax authority. It is necessarily so. Secondly, you are going to look at the nature of the dispute. If the dispute is a criminal matter or has its roots in a criminal, activity like tax evasion, that will not be a dispute for the purposes of the tax appeal tribunal. It's not one that we can adjudicate on. By paragraph 23 of the fifth schedule, the tribunal is a civil tribunal. The realm, our jurisdiction is in the civil realm only. And this has been emphasized by paragraph 12 of the same fifth schedule, which says that if in the course of adjudicating, the tribunal discovers evidence of possible criminality, it should pass on that information to the appropriate regulatory or prosecutory authority. So the tribunal does not have jurisdiction to hear criminal matters under any guise. Even if it is raised as defense, it depends. If it's raised as a defense and, it goes to the root of the matter before us, what we can simply do is to suspend hearing in respect of that appeal and then forward that information to the appropriate agency to investigate. We cannot even make a finding, because regular courts have general jurisdiction. They already are imbued with jurisdiction to hear and determine civil and criminal matters. So even when they are hearing civil matter and there is an allegation of crime, they can make a finding on it. We cannot make such findings. So the tribunal is strictly a civil tribunal. We are deemed to be one. And in fact, and that is what we are. So we do not meddle into that. Then, of course, the subject matter of the dispute is very important. Anything outside of laws stated in the first schedule to the FIRS Act is outside the purview of the jurisdiction of the tribunal. So this is how you determine whether your issue is one that can come before us. Now, once you have done that, once your dispute satisfies all of these three requirements, then you can proceed to file your appeal. Fortunately, filing of appeal has been made easy because you can now file your appeal online. The tribunal has introduced e-filing. And beyond that, we have also assisted in a way to ensure that you can file your appeal in any zone of the tribunal, any zone. Just go to any of our zones, you can file your appeal there. The only thing that you have to do is to properly head it so that from that zone, it will be transmitted to the zone with the jurisdiction to hear the particular appeal. All right, so I've given us examples. There are some cases here. There is a recent case, the Whitbaker Investment and Properties Limited against EFCC and FIRS. That kind of a matter cannot come before the tribunal, as a matter of fact, because of the nature of the dispute involved. And also you see that in Edmond Chinoye Obiagu against Lagos State government, the TAT said that the hotel occupancy law is not one that the tribunal can adjudicate upon because it's not within the remit of the tribunal. Just so that we understand that, selecting your forum is very important. So you don't come to us when you're supposed to have gone elsewhere. The next slide, please. The next slide. Okay, so now, how do you commence your appeal? You commence your appeal by filing a notice of appeal. The notice of appeal is an originating process. Yes, we call it notice of appeal, but you should see it more like your statement of claims. Why is it called notice of appeal? It's because something has happened between the parties prior to coming to the tribunal. But it is an originating process because before us, it is what starts the process. I would just like to point out one or two things when it comes to your notice of appeal, particularly to the appellant. When you are filing your notice of appeal, you need to know that some members of the tribunal are non-lawyers. I have seen people that will file notice of their grounds of appeal will be like they are filing before the appellate court. That is not what the law says. Go and look at our rules again. It says that you should state your grounds, the reasons. State the reasons. People will come and they'll say, oh, the tax authority, the respondent had a law when he did, the way it's not supposed to be that way. Just write in simple, everyday language. We have non-lawyers. There was a time in my panel that I was the only lawyer. Now imagine if I was not, for some reason, I was not available. Then it would seem like to mean that, none of the persons there will be able to look at the matter. Because point it in such a way that, it takes a lawyer to break it down. And oftentimes, because Aquila once made an observation, a valid observation that he made. He said it seemed like it's only the chairman of the tribunal that writes the judgment, or that guides everybody, and I just smiled. Now that is possible, and that will be the case where the processes are filed in such a way that only a lawyer can interpret it. And that will not be good for the tribunal because we have 5 persons. Each one should be able to bring their own expertise to bear. When they understand your process, it's easier for them. They don't need the chairman to interpret anything. So when you are filing, always have that. When you are crafting your grounds of appeal, always have that at the back of your mind. Always have that at the back of your mind that, okay, this is not a law court, and we have non-lawyers. Then for the respondents, from observation, some respondents will also file grounds of appeal. The law did not require you to file grounds of appeal as a respondent. What you are expected to file is the ground for contesting the appeal. So it is like you are traversing. And that's why I said that when you're preparing these things, always have it in mind that this is like, a statement of claim and a statement of defense. Always have that at the back of your mind. So because you cannot go off completely what, the appellant is asserting. Your grounds for contesting must oppose the grounds of appeal. So we need to understand that. And now, interestingly, the tribunal has introduced 3 additional procedures for hearing appeals. Before now, we only had 1 procedure for hearing appeals. It was the evidence-based, the standard evidence-based, means of it. Even then, there were times that we had to ask parties, because when we look at your cases, your processes, and we come to the conclusion that it's something that can be argued on legal arguments only, on points of law. Sometimes we direct parties to just file their final written addresses. Sometimes the parties will ask us that, okay, they want to file written addresses that the facts are not in dispute. So we use our discretion in those days. But now, the rules of the tribunal 2021 has made provision for instances like that where an appeal can be heard even on documents only, so that you do not need to call evidence, and then it is not dependent on the tribunal to come to a finding that this is an issue that could be heard, by legal arguments. Now, please note that by Order 3, Rule 6, and because it's still part of our rules, there is a requirement that you will pay a security deposit, more like as a condition precedent to, hearing of the appeal. It's still in the rules. However, there has been some sort of intervention by the tribunal in the case of Investment Holdings Limited against FIRS and MNI Limited against FIRS, where the tribunal has held that security document, yes, is allowed, is there, but is not a condition precedent to hearing of an appeal. That it will only lie at the discretion of the tribunal once the service, the tax authority, satisfies certain, conditions, which are stated in paragraph 15.7 of the 5th schedule. The tribunal also observed in those cases that there seemed to be a conflict between, Order 3, Rule 6 and paragraph 15.7. And it has been held, and we know that already, that the rules of procedure cannot override the provision of law. So let's quickly look at the procedure for hearing appeals, which is the 3rd stage in an appeal. So I said that we have the standard evidence-based hearing of appeal prescribed in Order 3, Rule 7. Then we have the document-only procedure under Order 15, the case-stated method prescribed by Order 15, Rule 4, and the summary appeal procedure that is created under Order 16. So those are the 4 major ways by which appeals are now heard before the tribunal. Let me tell you that for the respondent, once you have received your notice of appeal, you are expected to appear. However, appearance before this tribunal is not by physically presenting yourself, and it's not by filing, like we do in the regular court, a memorandum of appearance. I've seen instances where people have filed memorandum of appearance before the tribunal. Appearance before this tribunal, please go to the next slide, please. Appearance before this tribunal is by filing your reply to the notice of appeal. Please note that. Appearance is by filing a reply to the notice of appeal. It is otherwise called the respondent's reply. Okay? So once that is done, then it is deemed that you have joined issues with the appellant. Usually before the introduction of the 2021 rules, when an appeal comes for the tribunal for the first time, it is ripe for hearing. We can actually proceed to hearing, and we still do that. Occasionally we do that. However, the 2021 rules has introduced a protocol, the pre-trial conference protocol. We did not have this under the 2010 rules. Now, of course, I'm sure we are all familiar with the pre-trial conference protocol, so I'm not going to delay us by discussing what that is. We already know that because it's a regular practice before conventional courts. But what I just want to point out is that it is not a mandatory procedure. It can be skipped, and most times, it will even seem that parties would rather just go straight to trial than try out, have some sort of evaluation, early evaluation at the level of the PTC. In my view, I would think that the PTC is very important because even at that level, the appeal could be concluded. If nothing, at least it will help us to streamline, the issues for determination, so that we already know where we are going when we go for trial. But just note that the trial conference is not a mandatory requirement, even though it is provided in our rules. Okay, so presentation of cases, and usually this will apply when we are looking at the standard evidence-based hearing procedure. For the
you try to round up because
wow.
we have 30 minutes. Yeah.
Wow. Okay, so
there will be a 1 hour question and answer session, so we still have the time to.
Okay.
So let me give you let's just say approximately, even 10 minutes is too much because this is 2:37. I was supposed to start by 4.
All right. So okay. Now the slide is very at least I tried to give us the basic things that we need to know about the other hearing hearing procedures. So when you look at the slide, you would read it, because there are things that we have been doing before now. Documents only, we do it also at the level of the High Court. You have summary appeals procedure is very similar to the 11 of what we have in the Lagos Court. It is very similar to it. Then we have the case stated. When a case is stated for the opinion of the tribunal, on points of law only. So you have that one. And so let's now go to the 4th stage, which is the conclusion. An appeal can be concluded in 4 ways. In 5 ways, actually. It can be concluded by the appeal being struck out, by discontinuance, by settlement, by default judgment, or by judgment on the merits. Then, quickly, I want to talk about the last stage, which is what I call the post-judgment procedure. And this is very important because people will file, these applications for the tribunal asking us to stay execution of our judgment. And each time I see that application, I laugh. Because by paragraph 16, if you look at the combination of paragraph 16, 1 and 3 of the 5th schedule, you will see that this tribunal cannot stay its judgment. Because once the tribunal has given its judgment, whatever amount a judge has due must be paid within 1 month of notification by the tax authority. In fact, whether you file an appeal or not is irrelevant. In fact, it is even a condition precedent to filing an appeal before the Federal High Court. And when you look at the Federal High Court Tax Appeal Tribunal Rules 2022, if you go to Order 5 of that rule, you will see that it is a condition. If you do not present evidence that you have paid the amount adjudged due, your appeal before the Federal High Court will be struck out. The good thing now is that before now, there has been that argument, and because of the challenge of refund. But now, that amount of money is not to be paid into the coffers of the FIRS. It is now to be paid into an interest-yielding account, designated by the Chief Registrar of the Federal High Court. So the issue of, and because most times when they are presenting the argument, they argue that, the FIRS might not be able to refund the money and all of that. So in a way, there has been some sort of balance in that area. So that if the appeal is decided in your favor, you have your money back, even with the accrued interest. So please note that the tribunal cannot stay the execution of this judgment. In fact, in one of the cases, the tribunal ruled that it will be easier for the camel to pass through the eye of the needle than, for for its judgment to be stayed. So I think we need to understand that. However, there is power in the tribunal to review its judgment. And then the instances are contained in the rules. So when you look at our rule, you see that we have power. We can review it if there is, some element of fraud and all of that. If the judgment was obtained by fraud, we can actually review that. So that's the only post-judgment application that we can take. There is no other post-judgment application that we can take. And we need to know that this tribunal has limited jurisdiction. People file things before us and they will say they are bringing the application under inherent jurisdiction of the tribunal. The tribunal does not have any inherent jurisdiction. Its jurisdiction is limited, even its powers. And this tribunal said this much in the case of General Telecoms and FRS. I've read that case. And I think for everybody who wants to appear before the tribunal, please, you need to go back and read these two cases. FRS, the ruling, FRS against General Telecoms. And then please read also Ohando Supply and Trading Company against FRS. When you read those two cases, the decisions of the tribunal in those two appeals, you will have a better understanding of the working and the nature of the tribunal. I think I want to stop here.
Okay.
If that's okay, sir.
Thank you, Larry Rasisi. That's a very explosive one, and I'm sure our members enjoyed it. And I know that they'll be coming up with questions later. At this time, I'm going to call up Honorable Justice Nnamdi Dingba to present what he has for us. I hope my Lord is still there. Hello, do we still have the Justice Nnamdi Dingba? Steve, can you reach out to him? I don't know what's going on.
Oh, okay, I'll call him now. I can't see him. He was here before, but let me try and call.
Yes, he dropped off.
I'll call him.
Was he?
Okay, so maybe I can fill in the gap while we wait for.
Yes, sir.
Yes, sir. Okay.
Continue.
Now let me quickly just point.
So you mentioned you mentioned two cases. I wanted to mention it again so that those who didn't get it will get it. The
Okay.
two cases you said.
Yes, I said FIRS against General Telecom PLC.
Okay. Can you give them the citation? Okay.
Yeah, okay. For for FIRS,
slide, right?
It's
your slide.
Yeah, it's in the slide. Okay. I think it's there.
Once it is in slide, because we're going to share the slide.
I think it's in the slide. It's in the slide. Okay. So let me just fill in the gap while we wait for my Lord Justice Dingba.
Okay.
Yeah. So if you look at my postscript, you'll see that I talk about recent decisions. And I think they are very important for us to take note of this recent. There are some decisions of the Tax Appeal Tribunal, and then there are some by the conventional courts which have impact on the procedure before the tribunal. Now, the first one there is the case of Skybank against Kwara State Internal Revenue Service, where the Court of Appeal held that the tribunal does not have jurisdiction to entertain personal income tax insofar as it relates to a state board of internal revenue. Okay, it's a very funny one because we have always entertained, appeals in respect of concerning the dispute arising from administration of that, act, by State Internal Revenue Service. We've always entertained. But the Court of Appeal, in their own wisdom, the Law Division came up and said, no, that the State High Court should be, the starting point. However, that was in 2021. But in 2022, interestingly, another division of the Court of Appeal in this other case, EcoBank against Abia State Board of Internal Revenue, now said that Section 60 of PIT as amended has laid down a procedure for anyone who disagrees with the tax authority. And that procedure was, sacrosanct, because you cannot jump it. It's a condition precedent to go into anywhere. And it's in respect, you can say that the matter is between a state internal revenue service and a taxpayer.
Yeah, I just called the Honorable Dr. Sitimba. He said he's having technical issues and he will resolve it and join soon.
Okay.
So you can go ahead while you wait for him, sir.
Go ahead, sir.
Okay. All right. So you see that. In my view, really, it's but well, it would seem that the matter has been resolved because we now have a letter decision which says that we can hear those appeals. And we have been hearing the appeal anyway, because taxpayers have been coming before us in respect of personal income tax. In Lagos here, we have so many. Our predecessors dealt with so many. And then for me, apart from the fact that the Personal Income Tax Act itself is a federal tax, and it has nominated a procedure for resolving, a dispute. Beyond that, we already know that the Tax Appeal Tribunal, in a number of cases, CNOC exploration, the Court of Appeal itself have said that this tribunal is a precondition. It is a precondition to both the State High Court and the Federal High Court. Now, if you look at Section 65 of PIT 1993, and I think that's where the problem is. The real elephant in the room is not the tribunal. I think the real elephant is the fact that appeal will lie from the tribunal to the Federal High Court, even if the assessment is in respect. And I think that's a major.
Somebody is asking, one of the participants is asking, can the slide be shared? We were sharing it before, if it is possible, I don't know.
Okay.
Whether it could be shared concurrently while you are making your presentation.
Please, can it be shared from your hand, please?
Yeah, Sarah.
Okay, we'll deal with it.
Okay.
But that is that on that one. It's something that impacts the procedure before the tax. That impacts the procedure of the tribunal. Now, when you look at the other two cases that we have underneath that, I'm talking about judicial decisions with impact on TAT, there are two cases there which were decided by the Federal High Court. Go to slide 18. Slide 18. Can you go to slide 18, please? Slide 18. Okay. No, 18. Okay. So you'll see these two cases, Chief J. W. Ella, Sons and Co. against FIRS and FIRS against West Atlantic Shipping Land Limited. Now, these two cases were decided by the Federal High Court. And in those cases, the Federal High Court overturned the decision of the tribunal on the basis that the taxpayer did not file a pre-action notice before instituting its appeal at the Tax Appeal Tribunal. That's the basis upon which the court, or at least, I think, in fact, that's the basis upon which the decisions were overturned, that the taxpayers did not file a pre-action notice before instituting their appeals at the tribunal. And I honestly do not think that pre-action notice is a requirement, because the Tax Appeal Tribunal, the proceedings for the tribunal itself is sui generis. It is a special procedure. Already, we are talking about an appeal. There has been something between this taxpayer and the tax authority. The whole idea of a pre-action notice is to put the other party on notice. The tax authority is already on notice.
That's
a notice of objection itself is a notice. But this is this is Federal High Court saying that the pre-action notice is a requirement, is like a conditional precedent. However, the tribunal seemed to have answered in a case which was subsequently decided, following these two, was decided by the South-South Zone, grants decent hotels and suites limited against FIRS, where the tribunal in its own wisdom held that pre-action notice is not a requirement, it's not a condition precedent. So I cannot make a definite pronouncement on this, but I can tell you that the tribunal, the South Zone of Tribunal, has held in its own wisdom that pre-action notice is not a conditional precedent to filing an appeal before the tribunal. And in my view, personal view, I think that the tribunal's position it seems to me to be a preferable one. Otherwise, we will be importing exactly what we are running away from for creating the tax appeal tribunal. By the time we begin to load the tribunal with so much, legalism and technicalities, the essence of having the tribunal will then be defeated. In fact, when we go back to look at the broad objectives for the establishment of the tribunal, it is one of these reasons. It is to do away with the technicalities, the legalities, all of those, technicalities and rigidity of the regular court. Is why we have this tribunal. So parties can come there. In actual fact, before this tribunal, a party himself can represent himself. You can actually come before the tribunal by yourself. It's supposed to be, a place where you can come on your as you are and make your case known without the rigors associated with regular courts. So when we begin to load the tribunal with all of these things, then we are going back to Egypt. It means that we want to go and take the onions again. Okay, I've talked about when I was presenting. I talked about Investment Holdings Limited and Eminent. These are cases or appeals or decisions which impacted, Order 306. So we know that the effect of Order 306 has been whittled down by reason of these decisions. So please feel free to file. You do not need to pay the 50%, except the tribunal in its own wisdom, based on evidence that is presented by the tax authority makes an order that you should pay the 50%. It is not a conditional precedent. So feel free to file, your appeals at any zone of the tribunal. Now, I want to qualify. I want to draw our attention to. I mentioned one case, Ohando Supply and Trading Company against FIRS. In that case, the tribunal said that you do not need to wait for NORA before you file an appeal before the tribunal. That the taxman's internal review mechanism is not a conditional precedent. Fantastic decision. I have no problem with it. However, you should note that if you are filing an appeal directly to the tribunal, you must do it within the 30 days that you have to file your objection. Let me take that again. This is very technical. Now, if you're not going to object, if you want to file an appeal directly before the tribunal, ensure that you file that appeal within the 30 days that you should have used to file your objection. The reason is simple. If you filed outside of the 30 days, okay, that assessment will have become final and conclusive. If you file your appeal outside of the 30 days limited to file your objection, the assessment will have become final and conclusive. Now you will note that the tribunal only deals with appeal. So if you want to extend time, what we can do is we can only extend the time within which you are to appeal. We cannot extend the time within which you can object. That power is vested in the board of the FIRS. So take note of that, because by the time you will now come, the substantium of your appeal will have been taken away. So we must be very careful when we advise our client that, okay, yes, you can file directly before the tribunal, but you must do that within the 30 days limited for the filing of your objection. Otherwise, the assessment will have become final and conclusive, and there will be nothing for the tribunal to do. Alternatively, if you see that you're already outside of the 30-day window, you can still bring an application before the board of the FIRS. If they refuse that application, then it becomes a decision that can be appealed before the tribunal. Remember that the jurisdiction of the tribunal is triggered in any 4 ways. If you are dissatisfied or aggrieved with an assessment, with a demand notice, with an action, or a decision of the tax authority. So if you ask them now to extend, even if it's 3, 4, 5 months after, that you're asking them to extend the time for you to object, and they say no, you can appeal on that decision to the tribunal. But you must ensure, if you want to file directly in line with the decision of the tribunal, under trading and under supplies and trading company, if you want to file directly to the tribunal, please do that within the 30-day limited, so that your assessment or your client's assessment does not become final and conclusive. So this is very important. I think we need to note that. And that was the decision of the tribunal in the case of United Assets Management Limited and another against FIRS. Is reported in our own tax law report. The tribunal has its own tax law reports. I hope you know that. And most of our judgments too are reported on our website. So when you go to our website, you can access some of our judgments. I think they are periodically published. But we have our own tax law report, so you can also get in touch with the Secretariat of the Tribunal if you're interested. You will see our decisions, and they can also, guide you in what you do, particularly for those who have not appeared. And I'm sure if you take a survey now, I'm sure a lot of us, more than 50% of us, will not have appeared before the tribunal. So, but by the time you read some of our judgment, they will form, they will give you some guidance on what to do and what not to do. Now, the decision again in Orlando is further qualified by another decision of the tribunal in the case of Capital Oil PLC against FIRS.
I think Justice Dimba have joined.
Oh, okay.
Maybe my chairman, you may need to round up.
Okay,
Well,
so
yeah,
I think I will just stop at this point. I was just doing, Oliver Twist. So I think I'll use the floor.
Yeah, Lanre Lasisi, you've done a good, very good job. Thank you very much. Very, very decisive. We appreciate that. Honorable Justice Dimba will take over, but I doubt if my lord doesn't have much time. We may give you 15 minutes to present whatever you have, because this time supposed to be question and answer session. We're supposed to have gone into question and answer session by now. So you can briefly present what you have, Honorable Justice Dimba, so that we'll go into question and answer session. Thank you.
Okay, so thank you very much. And I have to apologize for the technical problem that I had. You know how it is. We're talking about money. You've seen an example of the lack of sufficient funding of the courts, because if the courts were that fully funded, obviously through tax revenue, we wouldn't be having the sort of problems that we just experienced live, now on this occasion. So but I apologize nonetheless. And I just want to also start off from where my brother Lasisi stopped, or on a point which he made when he said that the TAT is not a court, that it is a very relaxed process and all of that. I do agree. The only to the extent of saying that the only thing which is quite relaxed about the tax disputes is the assets that you have at the Tax Appeal Tribunal in regard to its flexibility in relation to the rules of evidence. Other than that, tax is very contentious matter, which you all know. And I remember that even when I was in the law firm and had to do like cases at the Tax Appeal Tribunal, so it was such a very highly contested thing. And even the matters that come before me at the Federal High Court, that is also so the same. So it is a highly contestable matter. And we also saw it even when you look at the dispute between the Rivers State government and the Federal Board of Inland Revenue and the uproar that was thrown up by that decision. It all goes to show how complex, how fractious, how contentious tax is. So this background then leads me to make the next point that I want to make, which is that when it comes to the adjudication and the resolution of tax disputes in relation to the powers of the courts, we must have to recognize that everything is as defined, regulated by statute. The powers of the court to intervene in tax disputes is as defined by the statute. The courts cannot go beyond, cannot orbit beyond what the law has provided for. And in relation to the Federal High Court, talking about its relationship with the Tax Appeal Tribunal in matters of resolving tax disputes, the background and the details of which my brother Lasisi had laid out very, very beautifully. So I think the first reference point has to be the FIRS Establishment Act that sets up the Tax Appeal Tribunal under Section 59, and then made detailed provisions for this on the 5th schedule to the FIRS Establishment Act. Under that 5th schedule that then talks about the process for assessing the adjudicatory facility of the TAT, notice of objection, file an appeal, and all of that. There is then a provision that says under Section 17 that anybody who is not happy with a decision of the Tax Appeal Tribunal, which Lasisi had laid out, if you're not happy about it, you can then approach the Federal High Court where I preside to appeal that judgment. And it says it has to be on points of law alone. That's the first restriction. And if you look at Section 17 of the FIRS Establishment at the 5th schedule, the Section 17.2 of it then says that he didn't file a notice of appeal and which has set out all the grounds of law on which the appellant's case is based. So this has already, restricted aspects of a taxpayer who is not happy to the Federal High Court by saying that it has to be, if you're going to appeal what the tribunal has said, which you're not happy with, you can only do that on the points of law, and then your notice of appeal must then set out the grounds of law upon which you're appealing. Meaning, therefore, that if the party is not happy with the TAT, what the TAT has done and wants to approach the Federal High Courts, and then makes all sorts of complaints in his notice of appeal. So some of those grounds of appeal are going to be invalid, irregular, liable to be struck out or recognized if they talk about factual issues other than purely legal issues. An example of that is if you look at the decision which I asked should be forwarded, and that is the case of R&B Falcon Exploration Company, LLC, and the Federal Inland Revenue Service. And that was a case which I did on the 22nd day of May 2017. I rendered a decision. It was an appeal from the Tax Appeal Tribunal in Abuja, and it came before me over its judgment. And if you look at that decision that I said should be shared with all the participants, you would see that even in framing the issues for determination, they were all purely legal issues that were framed. They were not factual at all. Issue number one was one about jurisdiction of the Tax Appeal Tribunal. I will come to that. These are based on the Federal High Court's jurisdiction. We look at powers of interpretation, whether it was right, the way that the tribunal held that that part of the turnover attributable to the fixed base as used in section 31B of the CETA means the entire applicant's turnover from its Nigerian operations. If you look at the entire issues for termination are all purely law. And even the three that were formulated by the respondent, the FIRS in that case, were purely factual, legal. So the first thing, therefore, what emphasizing is that approach us when you're not happy with what the tax appeal tribunal has rendered in its decision. But you have a very small wiggle room. Your wiggle room isn't that large. It's very narrow wiggle room because it has to be purely on the basis of law. Then the other thing I just want to also touch about here, because which is tangential to the point I made earlier on. Why are you going to restrict access to the Federal High Court from what the tax appeal tribunal has done to the points of law alone and the grounds of law? Why? Because if you look at section 25111A and B of the Constitution, it says the Federal High Court has original jurisdiction to adjudicate on matters that touch upon the revenue of the federal government and on matters in which the federal government and its agencies are also parties. Clearly, anything about tax touches upon the revenue of the federation. And when there's a matter that concerns the tax appeal, the Federal Board of Mineral Revenue, that's an agency set up by law as an agency of the federal government. So clearly, all these falls squarely within the literal interpretation of section 251A. And that is the reason why a number of cases have come before the courts challenging even the powers of the tax appeal tribunal to adjudicate on disputes. Why? Because you said all the factual elements of disputes would only be entertained by the tax appeal tribunal. And by restricting the right of appeal to federal High Court only to law, it means that what you're saying basically is that the tax appeal tribunal is not appealable at all once it has to do with facts. Okay, because if you appeal based on facts, that means that you're now is any competent grounds of appeal and therefore cannot be entertained by the Federal High Court. Therefore, it has its jurisdiction hamstrung by that sort of provision. So on that, on a pure forensic basis, you will see that on whether the tax appeal tribunal's existence violates or conflicts with the Federal High Court's jurisdiction and therefore null and void to the extent of business consistency. It's a position or a question that has received mixed judicial reactions, some of which are diverse. There are some cases that take the view that the tax appeal tribunal establishment existence is in violation of the Constitution because it challenges the original jurisdiction of the Federal High Court. And there's a case that Demola did, which is in the paper, which I will later on circulate. I talked about it when you say that the tax appeal tribunal's existence violates the 251 of the Constitution, which defines the exclusive original jurisdiction of the Federal High Court. But there's also another set of cases that take the view that it doesn't violate. There's this case which I also made reference to of my decision in 2017 that I said must be circulated, the R&B Falcon Exploration Company Limited. There's also a case you see that one of the very first grounds, easy pick, was that the TAT was unconstitutional. And it was a very smart move because if the appellant succeeded in saying the TAT was unconstitutional, it would then mean pulling the rug of the decision of the TAT that said they were liable to pay tax as assessed by the Federal Board of Mineral Revenue. So when I looked at that, I came to the view that I don't think that is correct. One, because if you look at the jurisprudence case law, there's something which we call condition precedent to the activation of any court's jurisdiction. There's also something that we call doctrine of exhaustion of domestic remedies. So which means that if there are remedies already provided for within a statute to be explored, it is a condition precedent for you to approach a court. If you haven't first explored, exhausted those remedies avenue provided for in the statute, you cannot come to the court because your coming to the court will be a premature move. Case law abounds to that effect. There's nothing strange about it. So if the FIRS Establishment Act and the fifth schedule says if you're not aggrieved with a notice of assessment made on you, notice of refusal to amend, all of that, approach the tax appeal tribunal. For me, it's something which it resonates with me. I don't have any problem with it, even from a commercial law point of view, even from the point of view of overall efficiency. It resonates with me. Why? Because when it comes to appointing judges of the Federal High Court or other judges, nobody says, oh, I'm going to look for you, Namdi. Do you have a degree or in taxation? Are you specialist in tax? No. Or they don't say, oh, Justice Wite or whoever. They just appoint you once you've achieved 12 years or 10 years post-call in the Constitution. You understand that? So, but that then means less efficiency. Whereas the tax appeal tribunal members are those who are specialists in tax matters. They understand tax. Therefore, they're in a very good position to appraise whether the agency was correct or not in its assessment, and whether the dispute that's mounted by the taxpayer is correct or not, looking at it, from the precedents and the rubrics for assessing tax, because they've been schooled in tax. You understand? So on that basis, therefore, I think there's nothing wrong with saying that let the matter first of all go to a specialist body made up of people who understand it as a condition precedent for it to come to the Federal High Court. I think that even enhances overall efficiency in adjudication. And the thing that I also made reference to in that judgment of mine is that if you look at Section 29 of the Federal High Court Act, it subjects the decision of these appeal commissioners that we had before to review by the Federal High Court, which is a revenue court, isn't it? Because Federal High Court started as a Federal Revenue Court. You see, so it's more like inheriting what was there before. So if we had appeal commissioners before who had to take decisions, whatever they said would then be subject to further review by the Federal High Court. It was just a continuation of what existed when you had the Federal Revenue Court. Exactly. So there's nothing wrong with that at all. So when I looked at that, I came to the view that I didn't think there was any usurpation. What has really happened is that as a condition precedent, you have to look at that, exhaust the method remedies before you then come to court. And can I also make this point? For those of us who are versed in arbitration and who are very knowledgeable in it, there's a concept called court and average clause when it comes to arbitration that says that you have to first of all.
My lord, some of our participants are saying that you should raise your voice so that they can hear you.
But this is the way I speak. I don't know how I'm going to do it.
So they're complaining they can't hear you. Okay.
So that was that there's something called the Scots and average clause in arbitration, which says that you have to first of all have gone to have an arbitration proceedings. Evidence of that having been exhausted is a condition for you to approach the court. So I'm saying those principles already exist in jurisprudence. So there's nothing wrong with having a similar thing in the area of tax adjudication, where you say that a matter should first of all go to a tribunal that is people who are very knowledgeable in it before it can come to the Federal High Court. That's what I said. But even happily for us anyway, is the fact that the Court of Appeal itself has given decisions. That Ademola's case, that Ademola said TAT doesn't have the decision, went to the Court of Appeal on appeal. And FIRS won because the Court of Appeal said that there is no conflict, that the TAT is just an administrative body, not a court, that sort of thing. And it was just a matter of decision of domestic remedies. So that one is saved, but clearly it would be very nice for us if we can have a definitive Supreme Court pronouncement on that clearly says tax appeal tribunal, it's constitutional, it does not conflict with the Federal High Court's in the jurisdiction. The other point I just wanted to touch upon is in terms of development when it comes to Federal High Court, is that you will see that even the Federal High Court itself seems to recognize that there is nothing in the TAT that conflicts with its jurisdiction. And that's the reason why you now have this Federal High Court tax appeal tribunal rules, both in 1992 and 2022. Because if we had come to the view that the TAT is an encroachment of our jurisdiction, we wouldn't have gone to be making the TAT tax appeal tribunal an appeal rules to the Federal High Court, detailing the manner in which appeals can come to the Federal High Court. So I think the Federal Court itself accepts that there's nothing that's unconstitutional in the TAT structure. One other development I just wanted to touch upon was this Federal High Court, Federal Board of Inland Revenue practice directions. Okay. Very quickly, you know that the Federal High Court Chief Judge in 2021 did issue the practice directions that relates to tax disputes from the Federal Board of Federal Inland Revenue Service. Part of the key features is that the FRS can file ex parte motion, and then with that they can obtain orders that would freeze taxpayers' accounts. They are assessing the books and records of the taxpayers. They can also seal business premises on the basis of these ex parte motions. Once they are filed, we are mandated, we judges in the Federal High Court, to issue the orders immediately to assist the Federal Board of Inland Revenue. And then when they have obtained this order, fundamental order, far-reaching order, ex parte, they can then file a motion of notice where they will then get final orders, but then they're already enjoying the benefit of the relief they've already obtained ex parte, the freezing order and the sealing of premises and all of that. Clearly, this is being done to assist, I believe, the Federal Board of Inland Revenue in its job task, very difficult task of getting tax. People don't want to pay tax, as you know. Once it comes to money, they come up with all sorts of excuses. So it's meant to help them. But some of the problems that have also arisen when I was looking at reviewing what people have said is that if you look at the application to be made by the Federal Board of Inland Revenue and relief is going to obtain by motion ex parte, it says assessment. There is nothing to show to indicate that the assessment on the basis of which an approach can be made to the Federal High Court to obtain these helpful orders for the Federal Board of Inland Revenue that are final and conclusive. So it means that if a taxpayer is still, as the Nigerians say, doing strong head, they can just move on, file the motion ex parte and then get these orders, more like strangulate you and force you to, and even go ahead and then obtain final orders. Nothing to indicate that it is final and conclusive. Whereas if you look at what my brother Lasisi said in terms of his discussion of the procedure in tax appeal tribunal, you first make an assessment. If the taxpayer is not happy, makes an objection and asks you to reassess, have a fresh look at what you've assessed him as being liable for tax for in the light of fresh evidence or materials may have given to you, then you then come and do your notice of refusal to assess that NORA thing. These are the things that trigger. It's only when the taxpayer, he didn't within 30 days or so say, review this, reassess this, that it then becomes final and conclusive. If the procedure on the TAT hasn't been exhausted, on what basis should the FIRS then come to the Federal High Court surreptitiously to begin to get those sort of, powerful orders? It's something to worry about. But what I tell people is that when you say that the Federal High Court has jurisdiction on the revenue of the Federation, so what is implied there is that even though that's not an explicit requirement, what is implied there is that Federal High Court judges should also be experts in tax to a good degree, at least a degree of being just judges. So therefore, when parties come before us, what I would do myself if I were the one this kind of application comes to, I'm going to be looking at the affidavit evidence to see whether there is any deposition to the effect that that assessment is final and conclusive and the circumstances, or they've gone to the TAT and all of that. If I don't see any of those depositions, all this evidence that I need in the affidavit evidence, I will refuse to grant that application, notwithstanding the fact that the practice direction says once you see that Federal High Court judges, as I say, it's all done to try to help these people. But then you're a judge, your duty is to be neutral, stand there and be just according to the law. So I would ask for that. So the power of the Federal High Court being dominated to somebody who is in charge of your court means that the things which legislation hasn't provided for, hasn't made complete provision for, you must use your powers, the knowledge of the law, being in control of your court to fill those gaps here. The gap to fill it is to say, I haven't seen it. I'm aware that this is what the FRA Establishment Act says. I'm also aware that's what the official says. I haven't seen evidence of the fact that this assessment, this tax issue is final and conclusive. Therefore, I am not going to grant you this relief until I say this is the position. You see, because if they then lie about it, it then becomes a very serious matter, because it means that you've gone to lied in your affidavit evidence. So the other thing is that, which also relates to this, is the fact that there are concerns that by the manner in which the price direction has been framed is as if it has bypassed the tax appeal tribunal, which is a different way of saying the point I made earlier on. So if they think they're going to bypass it, as a judge sitting, you must say this is what the law provides for. The only way to see it, ask them questions. Have you gone to the TAT? Because one thing I've noticed in my court is that sometimes people come, they're trying to play smart. They think you judge, you're not knowledgeable. By the time I ask one or two questions, they understand you know what you're talking about. You see them shifting on their feet, embarrassing it because they put them, hands down. So that's that one. So the final thing I would just like to say, or a couple of things I would like to say, is that one, and I think it's more like a rehash of a point which I had made earlier on. In the Federal High Court, we do recognize that I recognize the fact that I'm not that knowledgeable in tax. I probably know more tax than, because of my background, than some other people. But generally, we would say that we have to recognize our limitations, limited knowledge of tax. Therefore, anything that comes from the tax appeal tribunal should be given a good measure of believability, that sort of thing. They say, yes, I'm going to respect this. And there is nothing that is difficult about it. There's something that we call the judicial difference, doctrine of judicial difference, or what we call the Chevron doctrine, which is that what it says is that the courts must defer to in interpretation of statutes that have been, made by agencies that set us specially for that. So whatever that the TAT does and the FIRS also does as well, in terms of interpreting statutes, in terms of saying it's correct assessment, the courts must begin from the position, first of all, that they're correct. You understand? That's judicial difference. Defer to them. That state they're correct. And why I say that is that almost most of the decisions which have come to me from the tax appeal, when I looked at them, I was happy. I didn't have any cause to overturn anyone. And I think it was very consistent with the doctrine of judicial difference, the Chevron doctrine, the doctrine in Chevron case. The second point is that even when we say that we're going to defer, when you see something that is obviously wrong, you have to also correct it. If you look at my case, the case which I gave you, RMB, the decision which I said people should read, you will see that part of the whole in that case was that that a circular that had been issued by the FRS was not binding on the FRS because the circular was not a law. You understand? In my view, I came to the view that the tribunal was wrong. They shouldn't have said that. It is right. It is binding because when you make a circular in a highly regulated environment like tax, you issue a circular which people are going to believe in, which people have acted upon. That creates what we call legitimate expectations. Legitimate expectations. That's an obligation. How can you then make people to have expectations which are legitimate, that you're going to act in a certain way, and then you come back and reconcile and say, I'm not going to, it's not binding on us because it's not law, it's just mere guidelines. I don't think that is correct. In the case, the TAT took the view that circular 31 was not binding, it was just a guideline. I said, no, it is a binding document under the principle of doctrine of legitimate expectations. So the reason why I refer to that is that even though we say we're going to assist because all of us derive our sustenance from the revenue of the Federation from tax, and that following the doctrine of judicial difference, Chevron doctrine, would always define respect what the TAT has done.
Yeah, my lord, you have about 3 minutes to round up.
Yes, Jude, I'm rounding up. Yes.
Okay.
So even though we say we're going to defer, recognizing our own limited, knowledge of tax, the fact is that even when there are cases of clear wrongdoing, matters of law, we are going to intervene and correct them and make them do the right thing. And we saw an example of that, as I said, in my judgment in the case, which I essentially circulated, where I said no, that I thought that the circular created principles of legitimate expectation and therefore binding upon the Federal Board of Mineral Revenue Service, contrary to the decision or position taken by the Tax Appeal Tribunal. So I think, Jude, I would just halt my intervention at this stage, mindful of the fact that I didn't come in on time because of the technical handicap here.
Yeah, thank you, Justice Dimba. That's a very nice one. And I believe we've learned a lot from you. Currently, the time now is for question and answer session. We have almost 20 questions here, so I don't know how many we're going to handle, but let's start from the first one. And when the question is asked, any of you can decide to answer that. But if one is specifically directed to one, then the person will answer it. The first one was asked by Uchechi Anyanele. I should say, thank you for being here, Honorable Justice Dimba. Reading your judgments in the R&B Falcon and FIRS case was intellectually stimulating. Please, what is the meaning of the word recharges used frequently in the judgment with reference to the transaction between the appellant and its Nigerian subsidiary? She wants to know the meaning of the word recharges.
Okay. The way I saw it from the judgment there was that I think there are certain expenses which had been incurred by the subsidiary, and which were more or less, I think they were backed out when they were assessing what the tax exposure was. The argument was that should it form part of the pool subject to taxation, or should it be backed out where it has been backed out, removed by the company before they said this is the income that we have derived. So that's what it was. It was all those expenses that had been incurred by I think it was incurred by the subsidiary, which were removed from the revenue before it was then presented to the inland revenue. I said this is our income for the year. So that's my understanding of that.
Okay. Thank you, my lord. This question is from Anonymous. I think this question should be for Larry Lasisi. Please, I did not really get what NORA stands for. And that is the person's question. And if it is possible for Mr. Lasisi to also, briefly take us to the steps before you get to NORA and the periods and all that. That will help.
Okay. So a quick one. Now, if you look at section 69 of the Companies Income Tax Act, it provides the procedure by which a taxpayer who is dissatisfied with an assessment may object. Now, it says that you can file an objection within 30 days of the assessment, and then ask the tax authority to reassess in a desired manner. You state what you think should be your liability, the tax liability. And oftentimes what would then happen is that the tax authority will then constitute, sometimes there will be a meeting, a conciliation meeting or reconciliation meeting between the two parties. Sometimes it is done, by documents or by correspondence. Sometimes it will be between the consultants to the taxpayer and the tax authority. Now, when that is done, there are two things that the tax authorities could do. When you dispute it and say this is how much you think you should pay, they can accept that and then issue you a notice of amended assessment. So it will be based on what both of you have now come to agree as your tax liability, because it's a product of reconciliation. They can also say, no, we are insisting that our original assessment, that assessment that we gave you, based on probably, an audit exercise that we conducted. In Nigeria, the procedure, we have adopted the self-assessment regime. So you self-assess yourself, and verify your returns, and then put evidence of payment of that amount of money. Oftentimes, the tax authority will say, okay, no, we want to do an independent one, so we are coming to do an audit. And so when they come for the audit, they might find something different. And so they issue you, if you look at section 60, 65, 66, they can issue you, a reassessment, additional assessment. So that additional assessment most times is what the taxpayer is contesting by filing a notice of objection. So if they agree with you that, okay, all right, we have looked at it, we think you are right, okay, so we will then issue you an amended assessment in your desired manner. That ends it. But oftentimes it does not end there because the tax authority may want to insist on their position. So when they want to insist on their position, when they are disregarding your notice of assessment, they will then issue you what is called the notice of refusal to amend. So that is NORA. So that document, and let me tell you that oftentimes, you may not get a document that is headed notice of refusal to amend. In fact, in the case that I mentioned, this EcoBank against Abia State, the court held in that instance that the document that was called the final notice and warning in that particular instance constituted a notice of refusal to amend, because that was the final position of the tax authority. So once they issue you that, they are telling you, and that marks the end of the reconciliation effort. It is that point that you can say that reconciliation has broken down irremediably. So that is the notice of refusal to amend. It is usually issued like that. But then, of course, that sometimes they may even take their time in issuing it. The tribunal has held that if you do not receive a notice of refusal to amend within 90 days, you should take it that is a refusal, because they can sit on it. Maybe they are still deliberating, whatever they're deliberating on. But of course, you don't want to wait forever. So if after the expiration of 90 days, you have not received any notification from the tax authority, you can proceed to file an appeal before the tribunal. So you can take that as a notice of refusal to amend. So in other words, the notice of refusal to amend, NORA, do you understand, can take different.
Thank you, Lasisi. Thank you so much. Another question this question is from Stella Ejemma Obonna. She asked, is this tax appeal tribunal a court of first instance for tax cases?
Okay, so that word court.
So in any case, it's still a court?
That's the thing. So, but for whatever it is, because, like I said, paragraph 20 says that it will be deemed to be a civil court. And of course, when you deem something to be, that means that thing is not. So let's leave the issue. But then let's look at what I think the bulk or the crux of what she's saying, what she's trying to find out is whether it is the forum of first instance. In my view, I think it is. And Justice Dingba has also confirmed that, because it is a condition precedent. So you must go there first. And the reason is simple. You have 5 people who are sitting down. Let's even take out the legal practitioner. Let's say that one is even he doesn't know so much about tax practice. But you have 4 other people who are renowned tax practitioners in that they know almost everything about. They know the industry practice. And most times they even know the law. So, and because the focus of the tribunal is on facts, they are able to look at, the issues critically. And, Milord has said it, our appeal is usually on points of law. It is because it is deemed that the tribunal is a tribunal of facts. Because you have people who are experts, who are adjudicating. So we are not called, but when it comes to those taxes that are listed, contained in the first schedule to the FIRS Act, the tribunal, made up of tax appeal commissioners, will usually be the first place you go by virtue of the relevant provisions of the law, section 60 of PITA, and then the relevant provision of the Companies Income Tax Act.
Thank you, Mr. Asisi. We'll try to be very brief so that we can attempt all the questions. And
Okay.
thank you for properly using the word is the forum of first instance.
Yeah.
That's another question, Stella Ejamo Bona again, where are the tax tribunals located in each state or region?
Okay. We actually have a tribunal is located in each of the geopolitical zone. If you look at the slide, it's already stated in the slide. So you'll find one in Benin for the south-south. There is one in Enugu, that is for the southeast. There is one at Ibadan, that is for the southwest. There is one at Jos, that's for the north central. Then you have one in Kaduna. And then you have one in Kaduna is for northwest. Then you have one in Bochi, which is for northeast. Then because of the volume of what you have in Lagos, there is a standalone tribunal for Lagos, and there is a standalone tribunal in Abuja. In fact, because of the volume of the appeals that we have in Lagos, we now have 2 additional panels. So we have 3 panels, that sit and determine appeals in Lagos.
Thank you. Thank you, Lasisi. The next question is from Hassan Idris. Hassan asks, is there an instance where an appeal will lie from tax appeal tribunal to the state high court?
Well, unfortunately, the framework, the current tax appeal framework, seem to have somewhatly excluded the state high courts when it comes to adjudication of those taxes that are listed in the federal, in the first schedule to the Federal Inland Revenue Service Act. So appeal generally will lie, in fact, in all cases will lie from the tribunal to the Federal High Court. And there is even a case which involved, it was even filed by the state Inland Revenue Service, Osho State Inland Revenue Service against, what's the name of this case now? But there was a case that was filed by Osho State, and that they filed it at the Tax Appeal Tribunal, and then from there it went even to the Federal High Court, and the Federal High Court said that the State Internal Revenue Service is a competent person before the Tax Appeal Tribunal. And, even for the Federal High Court to have even assumed jurisdiction, it shows that, appeals from Tax Appeal Tribunal in respect of, those taxes will lie from TAT to the Federal High Court. There have been some, in fact, there has been pockets of, arguments, and I can understand that. I was going to point out something at the time that if you look at Section 65 of the whole PITA, you will see that it makes provision that, appeals can lie to the state high court. That provision is what we are lacking in the present, regime. And I think what we need to do, the policymakers, we should just align, tax dispute resolution in line. We should align it with the shared responsibility for administration of PITA itself, because you will see that by Section 3, the scheme of administration of PITA is shared between, the Federal Inland Revenue Service and the State Board of Internal Revenue Service. So all we have to do is just to tinker with the law that we have right now, so that appeals will lie from the TAT when it comes to assessment in respect of states to the State High Court, and the other one will go to the Federal High Court, so that we can have, we can correct this, what seemed to be an aberration. In my view, it seemed to be an aberration, really, that all appeals will lie from tax appeal tribunal, irrespective of where the origin to the Federal High Court. In view of a number of decisions that have held that the do not have jurisdiction in issues that have to do with revenue of a state. And of course, the tax is, whether we like it or not, impacts revenue of a state. So the policymakers may want to look in this direction. Thankfully, we have, the federal government tax force now that is, to look at these issues. I'm sure they will take an holistic view on all of these things and probably do something about it.
Okay, thank you. But if I may add to what Larry has just said, the problem actually starts from the legislative framework. I guess if that is a problem. If you look at the FIRS Act, the FIRS Act established the TAT, I think section 59, right?
Yes.
Now, if you go to the first schedule, you'll now see the jurisdiction of the TAT. And the listed that TAT has jurisdiction over matters arising from several statutes. And one of the statutes there is Personal Income Tax Act. And now, if you go to the Constitution itself and look at the subject matters that falls within the exclusive list and the concurrent legislative list, items 58 stamp duties, 59 of the exclusive legislative list deals with income, personal and corporate income tax, targets, and all that. Now, if you move to the concurrent legislative list and look at item 7, item 7 only says that the National Assembly could delegate or give that power of tax collection to the state tax authorities. So there's a difference between tax imposition, the power to impose tax and the power to collect tax. So what the state has is the power to collect taxes. The State House of Assembly cannot amend PITA.
Exactly.
They cannot make any law with respect to the taxation or changing the rate of PITA. So it's a constitutional issue. So for you to say now for the state court to say, okay, any matter arising from personal income tax, let this with the state court. The first question ask yourself, who is the maker of the statute upon which these taxes are collected? Is National Assembly as it deems the let's say under the existing law clause of section 315 of the Constitution, because these were military decrees which are deemed to be an act of the National Assembly. So I think if there's going to be any amendment to any issue, you have to start from the Constitution. You have to start from the Constitution, because the Constitution empowers the National Assembly to enact the PITA, and also the FIRS Act empower TAT to adjudge cases arising from PITA itself. So I think these are the issues. But anyway, I believe that if my Lord has anything to say, that the people will differ. At the end of the day, we're going to, whatever they say, that's the law. I don't know if my Lord has anything. If not, I'm going to read the next question.
I'm in agreement with your assessment of the situation, so I don't have anything more to add on that. Thank you.
Okay, thank you, my Lord. Now, the next question from Ayotunde Ogundare, can we use this? Oh, that's not a question. Chike Anyanwu asks, Mr. Lanre, on considering the nature of dispute, you refer to page 20. It's a 35 schedule. Is tax perversion not criminal?
Tax evasion.
It should be tax evasion. But he said tax perversion. I don't understand what he said about tax perversion.
It's evasion.
Yeah.
I think you've answered this question before. Yes.
Yes, tax evasion actually is a criminal issue. And so it will not be an issue that, because when you look at the legislative instrument for most of these are taxes. But if you look at like a CETA, for instance, you will see it has a robust criminal provision. It creates offenses. Then if you look at even the body of the Federal Inland Revenue Service itself, you will see that there are some, if you look at section 8, some of those powers there, you will see that some of those powers they can give rise to criminal matters. All of those ones are issues that we cannot deal with. They are issues for the Federal High Court. Anything that has, allegation of crime cannot come before the tribunal. We cannot see it. Our eyes are too civil to see anything. Let me put it out.
Okay, this question, well, is not directly to what you present, but I don't know. We can put the question is being asked by Marcos Eyaho. There are two questions in one. Is personal income tax to be paid to the federal government?
Okay. It will depend. The residents, even the residents of Abuja, and I understand that the Internal Revenue Service of Abuja is asserting its right to even collect personal income tax of residents of Abuja. For those who are in government services, the police, army, diplomats, all of those ones, yes, their personal income tax, administered by the FRS, while every other person, individuals, unincorporated bodies, all of those ones, they are collected by the state. So personal income tax, the administration is shared between the federal and the states, depending on who is paying the tax.
The next question by the same person: is a demand notice mandatory before a complaint of non-payment of tax can be instituted against a taxpayer? Is demand notice mandatory?
I don't think so, because now if you look at what the law says, it says that if you are aggrieved by an assessment or a demand notice, it means that once you have been served with a notice of assessment and you refuse to pay on it, if they just want to be magnanimous, they can issue you a demand. They don't need to issue a demand notice, because it is enough that they have served you with, a notice of assessment. Sometimes the tax authorities will go beyond that now to issue you, a demand notice. But I don't think that it is a condition precedent. That's my view.
Yes, sir. The next question is from Charles Williams. As a public body, can one not appeal the decision of the tribunal not to extend time directly to the High Court by way of judicial review?
I don't seem to get that question.
As he said, as a public body, can one?
Yeah.
I don't know. As a public body, can one? Let's try to make the meaning from what. As a public body, can one not appeal the decision of the tribunal not to extend time directly to the Federal High Court by way of judicial review? I think he's trying to say whether you can appeal directly to the Federal High Court for refusal to extend time.
No, because I think maybe what he was trying to say is that, if you're not happy with what the Inland Revenue has done and you want to approach the Tax Appeal Tribunal, you have to do that within a certain number of days. So assuming that he then approached the TAT, and then you have a prayer for extension of time, which was not then granted by the TAT, would you be able to say, oh, I'm not happy with this, I'm going to have to challenge this decision of the since we're taking the TAT is an administrative body agency, not a court. Therefore, can you go to court and more like utilize the procedure for judicial review to make that approach? For me, what I want to say is that I don't think anything is possible in law. It depends on the way you formulate your cause of action. If you have a brilliant lawyer and they formulate their nice cause of action, it comes to Federal Court. I cannot say anything is impossible, in law. So my answer to that is I will just say it is a possibility and leave it at that.
Okay. Thank you, my lord. The next question is for Lawal Alabi. For those in diaspora, and considering the simplicity Mr. Lasisi talked about in the institution of a case at the TAT, can a case be presented without the presenter being in court to redress a cause?
Okay. Well, I think one of the things I missed out is that appeals before the tribunal now can be heard, electronically also. There's a provision for that. And so if it will be impossible, for a party to appear, I think the tribunal has, the power to order that the appeal be heard, electronically. So as it is now, we can hear appeals physically as you appear before us, or we can also hear it even by Zoom. So I think that's possible. That's the whole idea of the introduction of this hearing of appeal by reason of COVID-19 pandemic. So yeah, I believe so.
Okay. Thank you. Marcos Yahoo asked again,
what are the... You would like to say something?
Oh, sorry, my lord, sorry. I didn't get that, sorry.
just wanted to weigh in on what my brother Assisi, the point he made about virtual hearing, maybe to reassure those in diaspora, which the gentleman was. Wherever
okay.
you are, we can do your matters. Even in the Federal High Court, I do a lot of virtual hearings. I'm doing this presentation in Abuja. Yesterday I sat and I did a number of cases in my court, in my division, virtually from where I was, and I do that all the time. So I think things have developed very rapidly, positively here. And I think there's an assurance to be given to those that live in the diaspora, like the gentleman at yesterday. So you don't worry about it. If you have genuine disputes, they can be attended to by Zoom and some other means of virtual hearing. We've already.
Thank you, my lord. Thank you. Now, it's not just the tax appeal tribunal, but even the Federal High Court. So your matter can be handled virtually. My lord has stated that they also handle matters virtually. The next question is from the same Marcus. I think we'll have to let's review other people so that there's no time. Hassan Idris, in which of the Federal High Court divisions that a person who is aggrieved with the judgment of the TAT is supposed to file his appeal? I think my lord should help us here. He said, which of the Federal High Court divisions?
I think for that one, I think the TAT is organized in zones anyway. So you have the 6 geopolitical zones. They have TATs in different zones. So if anybody is not happy with any of the decisions from that zone, you should approach the nearest Federal High Court there. So if it's in the Enugu, TAT zone in Enugu, Federal High Court is in Enugu. The one which I handled when I was in the Abuja division, so there were decisions arising, emanating from the TAT, the Abuja zone of it, and that's what came to me. I think when I was in Asaba, it's the same thing as well. So I think that's
okay.
That's it.
Thank you, my lord. The next question is from Ibrahim Bello. Good afternoon. Which court is of the first instance between tax appeal tribunal or the Federal High Court? I think Lasisi has answered this before.
You first go to the tax appeal tribunal.
You have to go to the
You then come to the
But we are not a court, please. We should. I think we should always make that distinction.
I think the Court of Appeal held that it has quasi jurisdiction.
Even mere administrative bodies can exercise, quasi judicial powers. It doesn't change either. So yeah.
But it doesn't have the status of a court.
No, it doesn't.
Yes,
it doesn't.
When someone with court, take it as using the word court in a loose sense, not in a
okay.
Sort of,
okay.
Where do you first go to? So that's what my understanding of that. Where do you first go to get the matter? So
okay.
All right, sir.
Thank you, sir. The next question is from our partner here and a very tax expert in Templars, Igonika Dekole. Igonika asks, it's a great presentation by Mr. Lasisi Phillips and Justice Dengba. Would be interested to know what the opinion of Justice Dengba is on the restriction imposed by the 5th schedule of the FRS Act, which stipulates that appeals from TAT to Federal High Court must only be on ground of law. Does this not conflict with the original and even the appellate jurisdiction of the Federal High Court as granted by Section 251 of the Constitution? Second, is a pre-action notice required to commence an action against FRS before TAT or Federal High Court?
My answer to, my attempt to that is that from a purely forensic point of view, limiting the appeal to the Federal High Court on points of law, meaning that you have to raise grounds of law alone and notice of appeal, which I try to deal with. It's problematic, clearly, from a strictly forensic legal point of view, in the sense that it then means you're not going to be able to litigate the factual elements of the dispute before the Federal High Court, which court we already say has original jurisdiction. And the reason why we're saying that the TAT does not conflict with the Federal High Court, because we are saying that you have the window to approach the Federal High Court to come to mitigate that. So clearly, I think that one raises problems. And I think it would be important when you're like amending the act, the FIRS Establishment Act, to try to treat that a little bit. But having said that, I don't really think that I'm really worried about it, because all the decisions which I've looked at from the TAT on factual aspects, I was quite happy with them. I've litigated before the TAT, as a lawyer, and I was quite happy the way the tribunal rose and said, no, the the FRS, you're wrong on this, you're wrong on that, you're right on this, that sort of thing. This idea that you have more eyes, more heads looking at something than just less. So factually, I don't have a problem, with the arrangements, but legally, I think it does create, it's problematic, it raises problems in the sense that it then seems to take away from what we've provided for in section 251. And I think a way to address that would be to, during legislative amendment, to remove that restriction and make it open completely.
She wants to know something about the pre-action notice.
Yes, I think I remember that.
Whether it applies to the Federal High Court or the TAT.
I think there's
Mr. Larry also mentioned a case where the Federal High Court said, oh, you have to, there's no pre-action notice. And because of that, you've not fulfilled the conditions. And Mr. Larry actually said, okay, this matter actually started from the tax authority. You were issued you have a demand notice and all that, and at the end of the day, they decided that this is what you have to pay, in which case it has become final and conclusive, and the party need to appeal. So why should there be demand notice? And if at all, should it be, is it to the TAT or to the Federal High Court?
No, I think it's an issue of pre-action notices. If my recollection serves me correctly, I think it's talking about pre-action notice, pre-action notice.
Pre-action notice.
So to speak. So I think my recollection is that for when I was going through my decisions on tax, one of the ones I came across is sometime it was even in Orca division, was the case which I struck on the basis that they did not serve pre-action notice on the Federal Board of Mineral Revenue. So I think pre-action notice is applicable. There's a provision there in the statute. I think, unless I don't have it here,
okay.
But I think that.
I don't know if I can comment. Actually, section.
And Lanle, before you proceed, like I've seen in some cases, for instance, in some state, there are some states which will say that before you see them, you have to give them pre-action notice, even in tax matters. I think I've seen something like that either in Ebonyi State. I can't remember the state where I saw something like that. So in a case where the statute, maybe a state statute expressly states so, what happens?
Okay, so now this is my view of it. Section 55, I think 3 of the FRS Act, talking about limitation of actions, also now made provision for pre-action notice. But this is my view. I know that when you're interpreting, a section or a subsection, you interpret it within you must take a contextual view of it. Now, when you look at section 55 generally, you will see that it is actually talking about suits, actions that are filed before the court of law, properly so called. So, my own view is that section will only be applicable when, that pre-action notice will only be applicable when you are filing an action before the Federal High Court. Because you look at the whole of section 55 together, you will get the drift that is talking about court of law. Now, we need to understand the essence of the tax. Once we have, and I think one of the problems that we have is that there is no philosophical foundation for the tax appeal tribunal that we have, there is no theory underlining it. If we had a theory underlining it, it will help us to weed out some provisions that will not even come in at all. Now, if you look at the broad objectives of the tax appeal tribunal, one of it is actually to resolve matters, based on facts without undue adherence to technicalities and all of that. Once we begin to bring in all of this, and that's my argument, Then we are going back to the conventional court. We are just taking ourselves back. We are then doing is that we are defeating the essence of having, a tribunal of this nature, which is to expeditiously, determine appeals based on expert knowledge. By the time we bring all of these things in, and like I said also, the idea of a pre-action notice is to give that other person, an advance notice of pre-action. The tax authority is already aware because they have engaged each other at their level. There is Section 69 procedure. It is as a result of the failure of Section 69 procedure that they are appealing. So the issue is not coming to the tax authority afresh. They are very aware of everything. So they'll say that, okay, so you have to serve 3 months. And then our rule says that we must begin and conclude the lifespan of our appeal is, 60 days. So, we need to balance all of these things and then know exactly where we are going. That's why I said that there must be some philosophical foundation for tax appeal in Nigeria, which must then be understood by both the tax appeal tribunal and the Federal High Court. So that when they are adjudicating, because they will also be aware of the, the theory of tax appeal and the basis upon which, we are doing this thing. It will also guide and tailor and guide the, future trajectory of what we are doing, in a tax appeal. That's my view. I honestly do not believe that.
I don't know whether I can give my view on this issue.
Yeah, go ahead.
So my view is that you can sue the Land Revenue other than on tax assessment. The issue of notice, pre-action notice, will not apply to tax assessment. I can sue the Federal Land Revenue for other matters. They can infringe my right in other respects. So when it comes to those matters that are not related to tax assessment, that pre-action notice may apply, because already before even a taxpayer appeal to the tax appeal tribunal, there have been notices passed between the parties, and there have been also the Federal Land Revenue Establishment Act itself and the Personal Income Tax Act already have stated a condition upon which you can approach the court, and that is specific to those instances. So for other instances, for other general matters that are not specific to tax assessment and tax assessment, the issue of pre-action notice may apply. But when it comes to tax assessment specifically, the issue of pre-action notice will not apply, because there are specific procedure for approaching TAT on that basis. Of course, you can sue any government authorities on any matters. Yeah, that's general. So for those specific matters pertaining to assessment and tax assessment, pre-action notice provision will not apply. That's my view on that.
Thank you, Steve, for that explanation. Thank you. I agree with you, and I also agree with the position of Larry on the issue of pre-action notice. Charles Williams is asked, with the principle of deference, are litigants therefore not bound, is it to the Philistine then? Why then do we have to appeal any of their decision? Should judges not now be trained on taxation? I think we have to skip this question. It's not clear. Anderson Dejabada asked, both the federal and state government can legislate on payee. However, I disagree with you that they can always legislate on personal income tax. I've explained this, and I've started the constitutional provisions that personal income tax is a matter in the exclusive legislative list. Check item 59 of the exclusive legislative list. Under item 7, the only thing there is the National Assembly could authorize a state to collect taxes in any of those taxes in item 59, with the exception of corporate income tax. Okay, anonymous attendee, based on the inherent jurisdiction of the Federal High Court, is the court not empowered to grant a stay of execution of the decision of TAT? My Lord Justice Demba, this question is for you. Let me read it again. Based on the inherent jurisdiction of the Federal High Court, is the court not empowered to grant a stay of execution of the decision of the TAT?
The way the question was framed, it says, based on the inherent division of the Federal High Court, is the court empowered under it? My answer is that it is a possibility. There's nothing.
So you are saying yes, it's possible.
That's my answer. I said it is a possibility based on the way the question was framed.
Thank you. Thank you, my lord. Charles Williams, on the legitimate expectation principle, as the PEPT now said the principle of legitimate expectation be disregarded in respect INEC. Come on, we're not talking about INEC and Vivas here. I beg. Anonymous attendee, my lord, what is the plan to train honorable judges of the Federal High Court to have at least basic understanding of tax laws and provision? I think it is deemed already. I think it is deemed to have it. But my lord can say something about this.
When I spoke about our limited exposure to tax, maybe I was just been trying to be very humble, portray that.
Exactly.
We're not knowledgeable about tax. We're always getting trained all the time in different areas of law. I think just a while ago, during our annual vacation, we spent some time in England getting tax training, and it happens all the time, even in Abuja and different locations as well. So we're getting, our knowledge of tax is more than basic, I can tell you, with all the millions. Don't worry about it. I will just...
Thank you, my lord. And for Dr. Justice Dengba, I can confidently say Dengba is an exceptional judge, knowledgeable in commercial issues, tax issues. But with all due respect, not all the judges are like not all the judges are Justice Dengba. So, and having said that, I want us. This is my own question, kind of, even though I'm a moderator, but I'm trying to enlighten our participants. There are two views. One, if you go to TAT, for you to be chairman of TAT, you have to be a lawyer with minimum of 15 years standing, right?
Yeah.
For you to be appointed a chairman of TAT. For you to be appointed a judge of the Federal High Court is 10-year post-call.
Yes.
Now, at the TAT, you also have professionals like tax accountants, economists, and people who are versed in tax. So after their decision, it will lie before the Federal High Court. I have written an article published in Journal of African Law, that was in 2021, where I made a case for the establishment of tax courts, just as you have in other countries, so that we know the history of the Federal High Court. It actually started as a revenue court, but at the end of the day, a lot of things happens. Admiralty, a lot of issues are dumped on them. So how do you agree that it is better? Because if you have a tax court that has a jurisdiction, there is a court in itself, appeal could now lie to the Court of Appeal. Do you think that will resolve this issue of a tax appeal tribunal? My lord, I know what the judges at the Federal High Court will think and what other people will think. There are different views that I just want to hear from Lasisi and Justice Dengba. Do you think that will solve some of these problems? Because the question they're asking here, that people are saying, okay, it appears not all the judges at the Federal High Court has knowledge, tax, expert knowledge in tax, even though there are people who have expert knowledge in tax who are judges, like Justice Dengba. Can I hear from you guys, my Lord Justice Dengba and Lanley Rasisi? What do you think about this? And perhaps Stephen Arubika.
My Lord will speak first, or shall I bear the cards?
My Lord should speak last.
Okay. So now this is my view. You know, the global trend is what you said. Most jurisdictions, fiscal jurisdictions are tending towards, you know, especially adjudication of tax disputes because of its technical nature and all of that. And I think, okay, that's the way we should go. Now, the tax appeal tribunal, in a way, is also a specialist tribunal, but it is limited in various ways. There are two. I have also written so much. I mean, maybe not. I've not published some of my work, but I've written because I'm actually doing a book, and my observation is that the way the tax appeal tribunal is, it may not be able to fulfill, the purposes for which, it was set up, unless we probably have something like, a tax. We may not have a tax. There are other ways of specializing the court. For instance, we can create, if we don't want to have a tax, we can create a special division in the Federal High Court that will be manned by tax experts. Basically, there's no law that says the agency cannot create a special procedure for appointing people into that place. Man is not made for law is made for man. So we can then come up with a way of ensuring that we have that specialty even at the level of the federal. Because I believe that a generalist judge, really, that's my honest view. I do not believe that a generalist judge should be able, notwithstanding my Lord Justice has spoken about the difference to what we do at the Tax Appeal Tribunal, which is fantastic. But I still want to believe that most generalist judges would not have the requisite, that deep technical understanding sometimes of the things that we are talking about. And when they are looking at it on the surface, because of their training, the benefits or the advantages may completely be eroded of having a tax appeal tribunal. So in a way, I think it's good if we have that kind of thing. Either we have a tax court or we have a chamber or a division of the Federal High Court that is exclusively for tax dispute resolution. I think it will go well for all of us.
Thank you. Thank you, Lanre. That was actually the position I took in the article that I published. Maybe if after I will also share it for members to go to. Stephen, what do you have to say?
Okay, my view is that we need a specialist, a division devoted specifically for tax matters. Whoever is in the tax space as a legal practitioner will know that it is a very specialist area. So if you have it as a specialist area in practice, I don't think there is nothing wrong in also having a specialist court in the Federal High Court, especially division devoted for tax matters is very, very essential. I mean, I recall when we joined the legal practice, you can say I'm in corporate law. I mean, you cannot just join today and say you are in corporate law. Somebody will ask you which aspect of corporate law is it, energy, tax, M&A, and so on and so forth. So things the specialization is we have specialization in legal practice as we speak. So we also need to have courts that are manned by specialist judges or legal practitioners that have been in that space for a reasonable number of time, or they have distinguished themselves as specialists in that area. I mean, that can enhance our practice. But of course, the decision is purely administrative.
Thank you, my lord. Justice Dingba, can we hear from you?
Yes, my view is that, and I said that with all due respect, I think we also need to try to understand that there's a difference between what is idealistic and what is realistic and practical, okay? The idea to have a task force, manned only by tax people, specialists and all of that, that's a great idealistic point. But I ask myself the question, why do I need to get a new car? Do I want to get a new car because I want to improve the look of my garage, have an assortment of cars in it? Or is it because the cars I have at the moment are not functioning properly? If they're not, how do I make them to function more properly? My point is that, and honestly speaking, if one is sort of a special task court, that's okay. But I don't see that as that desirable, to be honest with you, because I think we can actually improve on what we have at the moment. I don't see what is the problem with the tax appeal tribunal. The only concern I have is the fact that you are now limiting a review of what has been done at the TAT to a higher court only on points of law alone, instead of the whole gamut of the decision process being looked at. We can improve the tax appeal tribunal system structure, and if we do that, that would then serve as the sort of this task court we're mentioning now. The second argument is that even when we say let us set up a new division, a new court, only to tax, it sounds so nice, but practically, how achievable is it? How many cases on tax do you think we have in a year? that would come before that particular court to be dealing with. So if we're going to set up a special court just for tax, maybe in the Federal High Court, that means we're going to set up also a special court for intellectual property disputes as well, for AMCON disputes, for insolvency disputes. So we just go on and on and on and on, creating special courts for different subject matters. I'm not a fan of, but we must set up every court for all sorts of things. I think if we use the existing structure, we can actually solve the problems that are facing us. If a matter comes before the Chief Judge of the Federal High Court has been fired, looking at the capacity of different judges, the Chief Judge should be able to say, I'm going to assign this matter to this particular judge who has knowledge and training in so and so field of law, which is what is actually going on now. But of course, we can actually do better what we're doing at the moment, because sometimes they have the feeling that when matters come and they just get assigned without maybe full consideration. But I would like to believe that is not the case. What I think should happen in summary is that we can improve the existing structure of the TAT.
Okay.
Legally, and then in the Federal High Court stage, make sure that when matters come up stairs, that the matters get assigned to judges who understand this, who have been trained in it. If you set up a special court just for that alone, I don't think that is necessary. I think it's going to be a white elephant project, with all due respect.
Thank you. Thank you, my lord. The next question
I have an
is
appointment.
from
Also, I have an appointment for 4, and I told Mr. Rubike about that. So if we're not going to
okay,
run up, I can check.
I think we're supposed to have ended it. It was because of the delay. We're supposed to have stopped by 4. So thank you. I think we're going to end it here. The materials for the presentation made so far, we started last Monday, is going to be circulated today, before the end of today, or at most by tomorrow morning. Everyone should get it. Thank you, Larry Rassisi Phillips, for your very incisive, very explosive lectures. We appreciate you. We thank you. Thank you, my Lord Justice Dingba, for your very powerful presentation, very authoritative. We're very happy with you, with 2 of you. And also we're happy with members of the MBA ICLE for putting this together. We thank all the participants who have been participating. May God bless you. And we're going to send the materials to every one of you. Thank you very much. Thank you. Bye-bye.
Thank you.